And hello, everyone, and welcome to the Copyrighted 2.0 show, episode number 360. I am Jonathan Bailey, as you can see from the bottom third below, and joining me as usual, attorney Evan Sherez, who I am certain will have something to remind us all of in just a brief moment.
How you doing, John?
Doing all right, doing all right. We got a lot of interesting stories today.
A lot of interesting stories, and as always, nothing I say it should be construed as legal advice, just my general opinion on matters.
Yeah.
Although I might be making an exception to that today. Stay tuned.
Oh, stay tuned. I am intrigued now. I have never in my life gotten free legal advice, but maybe an exception.
Could be coming.
Maybe an exception could be coming. That's very interesting. I've got to say, this podcast and the news this week, or news today actually, has made me very glad. My prom photo did not appear on John Oliver last night, on Sunday night.
Yeah, that was really interesting. I sent you that email earlier today.
Yeah.
About the gentleman who is works in media, and his photo somehow found its way to I believe it was
Getty Images.
Stock photo. Getty's stock photo, and then that ended up on Oliver tonight holding a bag of marijuana.
Yeah, it seems like the basic story was he went to prom in 1997, which coincidentally is the same year I went to prom.
Really?
So yeah, that's. I'm very glad I am more fortunate than this person right now, because no one wants to see my 1997 prom photo. No one. It's quite sad.
I would love to see that.
It's very, very sad. But no, basically what happened is he and his date had someone snap a photo of him, and it was a friend of theirs who was a photographer, I guess a budding photographer at the time, who had the foresight to get a model release from them. And they just, go build your portfolio, Godspeed. Years passed, the photo ended up, I'm pretty sure the photographer put it in like a giant bucket of photographs that they don't have anything to do with in particular, like photographers do, and ended up just taking that big bucket and licensing it through Getty. Then from Getty, it ended up on John Oliver's show. It's totally legit from a legal standpoint, but yeah, this is how media flows.
Yeah, I thought it was a pretty cool story.
It was a really interesting story. Thank you for sharing it. But it's not a copyright story. We do have a lot of copyright news this week. Let's do a quick preview of what's coming up this week.
Let's do it.
Okay, we're starting off this week with an update from the appeals court on the Innocence of Muslims case. Then we're shifting gears and talking about TV eyes and Fox News getting some pretty broad-ranging support, at least from its industry. Then we turn and look at Richard Prince, which I know everyone is going to be asking about. Then we have another story involving a photographer and him taking Pinterest to court over what he considers repeated copyright infringement. A musicians union is taking the film studios to task over reusing film soundtracks, which is interesting. And then we have the return of the great Sherlock Holmes this week, as the estate of Sir Arthur Conan Doyle files yet another copyright infringing lawsuit, but this one a little different than the previous one, I might say. And then we also have an update on the Happy Birthday lawsuit and a brief update on the Trans-Pacific Partnership as it moves forward and backwards and sideways.
I had the exact same reaction as you did with the Sherlock Holmes, and then the exact same second reaction that you had. We're like, oh, well, maybe this one might actually have some grounds.
It's like, oh, come on, again? Really? You got to be, hey, wait a minute. Hang on.
What's that clock? That clock saying, a broken clock is still right twice a day, feels like that.
Yeah, it does. It's really surreal. And this is after they got their metaphorical or proverbial butts kicked in a previous lawsuit. I'm sure we'll be talking more about that in a minute. But first off, we have an appellate court ruling, which is pretty special on this show. Type of stuff we love. And not only do we have an appellate court ruling, but this one's unusual because it's an en banc appellate court ruling, meaning the entire Ninth Circuit, well, I'm pretty sure almost the entire Ninth Circuit, a more complete Ninth Circuit, heard this case and overturned a subset of their peers in doing so. It's a fascinating case.
Yeah, we talked about this case a few months back, and maybe we touched on it briefly because looking back on it, I'm not sure that we recognize that the claimant was claiming an independent copyright rather than a piece of the copyright.
Yeah.
So that's an important distinction that that has to be made here, because I don't remember. I might have gotten it incorrect last time, but I've had the chance to really look at it in depth, and man, is this a cool case with a lot of interesting and really meaty copyright law.
Yeah.
So, for those who don't know, the Innocence of Muslims was a short YouTube, I don't want to even give the dignity of calling it a movie, but it was a fairly xenophobic and racist film about Muslims, which then blew up because it was used as a potential reason for riots around the world.
Yeah.
The long story short is that this poor actress who didn't know what she was getting herself into, didn't get to know the content of what she was doing. Her image and her performance was used in this video, and then all of a sudden she was getting death threats from around the world.
Yeah. And the actress's name is Cindy Lee Garcia, and I got to say right off the bat, there is nothing but like supreme sympathy for her.
Oh, absolutely. I feel the exact same way. And the court ended up saying, the same thing, regardless of how they ended up ruling, which we'll get to in a minute, which was that, there's no way of getting around it. This woman got totally screwed.
Yeah, she went, basically her story is, she is an aspiring actor, and she auditioned and thought she was performing in an action film, some kind of super generic action film 32 type thing, and she shot some scenes for it. And it was apparently a real skeezy operation. She never signed her model release or any of that stuff, the rights over, which is like, that's usually like step 0.01. It's like not even the first step. It's like you walk in the door, here's your papers, please sign. That never happened, which plays heavily into this case. And so she goes, she shoots these scenes thinking it's going to be just a generic action flick. And they go and they overdub her lines and making her appear to say these absolutely horrible things. And when the video blows up, she finds herself receiving death threats, and basically her name, her reputation, and probably her career are either severely damaged or ruined.
Right.
So there's like nothing but sympathy for me for her. But
so she ends up, hiring counsel, and they sue Google, who owns YouTube, to try to get this thing taken down.
She had filed DMCA notices, and they had declined to remove it.
Right. She ended up reading that she ended up actually suing on a number of grounds, including emotional distress, tort law, and of course copyright. And she issued a DMCA takedown notice before they sued, and which was not complied with because this woman was an actress, so Google was like, we don't agree with your copyright claim here. All you did was act in this film, so we're not going to take it down. So she ended up suing, for copyright infringement and a number of other grounds. What they sought was an injunction. We already get a really interesting little flavor on the law or injunctive law. So usually when you're suing for an injunction, one of the factors is that you have to show to the court that you're likely to succeed on the underlying merits of the case. So suing for an injunction is not a ground. An injunction is something you could do when you're suing someone for another reason, and you really want them to stop or start doing something right now. For example, if they're, in the issue of copyright, if they were, let's say releasing something that you owned, you would be like, hey, I want to stop you from releasing that. I own that. And so I'm going to sue you in copyright, and then I'm going to also sue for an injunction. And in order to get that injunction, I have to show that I'm likely to win on the copyright substantive part of the case.
Yeah. I mean, if you were coming by my house and punching me in the head every day at the same time, I would sue you for battery, but seek an injunction preventing you from coming into my house and punching me in the head every day.
Sure, yeah. That's a very, very good theoretical, simple.
So please don't come by my house and punch me in the head every day.
I will try to stop doing that, John.
I appreciate it.
Now, here's where, there's a little point of law to learn here, which is that the standard here wasn't that she was likely to succeed on the merits. The standard here was that the law and the facts must clearly favor her. And the reason that is that the injunction was an affirmative action as opposed to stopping you from doing something. So in California, if you want someone to do something, so if the court is going to compel you to do something, you have to prove that you're going to win with a more clear, with greater certainty, really. And so she had to show that they were likely to succeed. So that really raised the bar for the injunction.
Right. And the interesting thing about it is she went to the lower court. Google and others involved won in the lower court. She then appealed it to the Ninth Circuit. And the Ninth Circuit kind of turned everyone's heads. The Ninth Circuit ruled in her favor and ordered an injunction against the video. The video came down, and Google kind of did a snarky, why this video is down thing. But then Google went and appealed it. Now, they didn't. Now, normally you think of the appeal process as district, appeals court, Supreme Court. But Google did what's known as an en banc appeal, which basically said, hey, we want the full Ninth Circuit to take a look at this. Not just the panel of 3 judges we got. We want like 90 to come take a look at this case. And that's exactly what happened. And the Ninth Circuit came together in all of their might and glory and agreed to hear the case. And typically speaking, you don't hear about en banc appeals being accepted very often. That's usually just kind of a nah, we'll pass, send that on up to the Supreme Court and try your luck there type thing, which is literally a lottery system, it seems like. But here, the Ninth Circuit did agree to hear it en banc and did overturn its own previous decision.
Right. And the reason why I believe it was taken en banc, and the reason why this really sent shockwaves throughout, the creative community, is that this wasn't your run-of-the-mill, I own a copyright in the film, maybe we're co-authors, maybe we're not, but like I really, that wasn't her claim.
No.
Her main claim was that she owned a copyright, an independent copyright in her performance, in her portrayal. Yeah. And so, that was a kind of a creative argument that has always been rejected, but it succeeded. And so,
and this could have potentially major implications for
right.
Hollywood. You have movies with tens of thousands of extras. What if, they all have an independent copyright claim in their performance?
Right. So in order to, gain a copyright, you need to have an independent work of authorship with sufficient creativity that's fixed in a tangible means of expression. And so, she was like, the way I portrayed it is its own copyright. And just like on every level of, the elements of a copyright, it was just outrageously, incorrect. If you and for some reason the chief judge of the Ninth Circuit didn't see that and really wanted to go along with it. I mean, first of all, where's the fixation? There's only one fixation here. It's the film, and in order to get a copyright, when something is fixated, it has to be really you doing it or you ordering someone to do it. But the only person creating a film was the creator of the film.
By the way, it's not been heard from. It's worth noting. We haven't heard anything from this dude at all.
So I think it's pretty clear that there's no fixation. So you could perform something all you want, but unless you're putting it down permanently, either on film, on you're painting something. If there's no fixation, there's no copyright. And so that's one thing. I mean, the second thing would be like, where's the authorship? Wasn't she given lines? Was there anything that she actually created? There was just problems across the board here.
Yeah.
And it was really a case of this poor woman was screwed, and I think someone was trying to look out for her. There's no really great way to explain it, although it's worth noted that the Ninth Circuit, the Chief Ninth Circuit did dissent in the en banc decision.
Well, I mean, it's a situation where everyone agrees she got screwed, but also everyone seems to agree there's no real law to protect her here. Not at least along these lines. Not as far as getting that film taken down. If she wants to sue this guy who made the video, and if she's able to, and she can find him, step one in this, right? Then she has tons of torts available to her, She probably has all kinds of actions she can bring against him. I mean, just off the top of my head, a misrepresentation. You have all kinds of various issues that she can bring up to him. But yeah, you got to find him first. But as far as getting the video removed, there's not much you can do about that. But one thing I did find interesting, one argument she made that I found fascinating, was she also tried to claim that her performance was a pantomime, noting that a pantomime is copyright protectable. You can copyright a pantomime, and since her words were overdubbed, meaning she wasn't actually speaking or giving lines, she tried to equate her gesticulating on the camera with a pantomime performance, which I think is a stretch, but for creativity.
Yeah, absolutely. You know, Google put it best when they said that the argument would make a Swiss cheese out of copyright. You know, and if you think of Swiss cheese with like little holes in it, and that the policy implications behind granting copyrights in little, independent parts of what is essentially a collective work of film, creates a nightmare for the operation of the entertainment industry. So when you have 20,000 extras in Lord of the Rings,
or the latest Batman movie, or whatever. Like,
exactly.
I think they actually used exactly that many in the football sequences in Batman, the latest Batman movie.
So every person who thinks that their particular part of the film was sufficiently creative will have their own copyright, and it's a nightmare, And even if every company in the world would get licenses from every single one of these extras, those expire in 35 years, to give them with the renewal rights. There's just so many different.
Copyright termination, as you're saying. Yeah, there's a ton of headache here, and I think the court reached the right decision. I wish there were more we could do for this woman. It really is the truth. I just don't think copyright is the approach.
Right, and on that note, I think my final thought about this case is that it's an interesting study in how sometimes victories aren't necessarily good for you, because she's sued under a number of grounds, right? As I mentioned earlier, emotional distress, tort law, and they moved for the injunction based in copyright law and had it granted, and now here we are years later and it's been reversed. But those other grounds are still floating out there. So, you never know what sort of legal strategy decisions end up impacting your client 3, 4, 5 years down the road. And choosing the incorrect route may, come back to bite you. Because who knows if they had proceeded under some sort of emotional distress ground, they could have gotten it taken down and could have stayed down.
It's interesting, Silicon Valley likes to talk about fail fast, fail first. Well, there's no real way to do that in the legal system, is there? There's no such thing as fail fast, unless you epically fail. Well, there is a way.
There's always a way.
But like you said, a lot of legal strategies, no matter how doomed to failure they are, will take years to fail. So in this case, they did not fail fast. Well, I found this next one almost equally interesting to me, because you have Fox News getting support from a rival in CNN here. Against what I guess they see as a common foe in TV Eyes. Now, TV Eyes is basically like a digital. A lot of and PR firms, they would oftentimes refer to this as scrapbooking services or headline services, or services that basically collect information from publishers to present to people. What TV Eyes does is they record all of everything aired on a lot of these networks. Apparently, they find ways to tag it, to make it searchable, and they allow their customers that pay, I am sure, very, very large amounts of money to access this database, search for clips, view them, and to download them and to do things with them. Now, the idea here is that, like, if you're a company and you wanted to see every mention of your company in news, this would be an easy way to do it. You just simply search TV Eyes, you get a bunch of clips, and you don't have to pay someone to sit there and watch Fox News and CNN 24 hours a day. Go team. But Fox News is suing, alleging that this is an infringement on their copyright, and they seem to have a lot of support. Not just CNN, but NBC and CBS have also filed an amicus brief supporting the position that TV Eyes is an infringement, though so far TV Eyes has had most of the good fortune in the courtroom.
Yeah, so we have on our hands here amicus briefs being filed, which is a concept we've explored in the past. It's third parties who think they have an interest in the outcome of the case coming in and saying, hey, here's our opinion. And, these broadcasting organizations have nonprofit industry associations that do this all the time on their behalf, so it's interesting to see them doing it independently. This this is another really interesting case because my first thought was, looking at where Fox News is suffering. So I understand that, this is their copyright material. They can do whatever they really want with it. But when it comes down to a fair use test, which is what the court ended up talking about here, because that's the main defense for TVIs, which they're saying that, this is a transformative way of using their content, and we should get, the installation of fair use. I looked at their finances, and it was only a few $100,000 in syndication, which they're really losing. And so my first thought about that is, who syndicates news? Like news is old like 2 minutes after it's tweeted. So I'm curious who's paying for the ability to rebroadcast the news broadcast. And that's basically where most of my, I guess, opinions lie in this, is that if your news broadcasts are being recycled, what's your real stake in that? Does that make sense to you, John? So, news is one of those businesses that, once it's 5 minutes old, it might as well be,
Well, and this is something. And this is something we run across in other areas of copyright law, like, for example, hot news claims. We see this. I don't know if you're familiar with the hot news, quote-unquote, doctrine. It goes all the way back to the early 1900s. But it's the idea that when an organization like Fox News collects and does reporting at expense, they have not just a monopoly in the work that they create, but in the facts that they create for a limited period of time. Now, that limitation is extremely short, and it actually, the original hot news case dealt with telegraph lines and people subverting telegraph lines to get, to intercept stories from the Associated Press, I think it was, to get them to the United States fast. It was during World War I,
Right. There's obviously, those cases ended up, falling by the way, so there's no ownership of facts anymore.
No.
And
it's still somewhat relevant, and it still comes up once in a while. But yeah, it's such a narrow right. But yeah, that idea of news being old within minutes is definitely something that's in copyright law and recognized.
Right, and
was the main point.
It's one thing that, your print media, I think that you have a pretty clear right, to be able to keep that because stories are read and those remain relevant for a number of period of times. But like broadcast news, is that something that you really have a real interest in financially in order to argue that shouldn't be fair use? Because I think the numbers that Fox News presented make a pretty clear case that it's not a huge money making.
And it would be interesting to hear if maybe Fox News and these other guys are maybe considering launching their own TVIs-like service.
Mm-hmm.
Maybe this is something they're planning on doing, and here's TVIs, this outside party, sort of jumping the gun and beating them to it.
Mm-hmm.
That maybe this is a future thing for them. We've seen this before where copyright holders have claimed infringement, not in necessarily something that hurts their current business model, but their future business models.
Right. I think the service has a really good claim for, a real transformative use.
Yeah.
I mean,
well,
they index every hour of every day of these broadcast news programs, so that, as you said, companies can figure out who's talking about them, and police stations can sometimes use it to figure out is there something we need to be focusing on. And I don't know. I think you're going to end up seeing an affirmation of the fair use ruling in the district court, in my opinion, unless these companies end up actually launching a service like this that does, index, their programming like TVIs is doing. I think, and the equity is going to lie in the balance of the defendant here.
Now, the thing about it is the court has already ruled in favor of TVIs on the indexing issue and has ruled that to be a fair use in the court's eyes. That's already been set aside. Now, what else there is the TVIs has other features, such as the ability to download clips, whether or not they are, of various size. What size those downloads are? Are they 30 seconds? Are they a minute? Are they 5 minutes? I don't know. But also to archive, email, and share, I guess, via social media clips of shows. And those are the areas that are still under scrutiny right now.
Ah, so that's an entirely different question. Let me ask you something else. Do you know if they offer live streaming? Because that would, I think, be
It says that they do not. Wait a minute. No, it appears they do not offer live streaming, which would make sense but then again, even if they did, as it was pointed out by TVIs, basically they cost thousands of times more than a cable subscription. Why would anyone live stream from us when they can, you know what I mean? But
okay. So what remains to be decided is whether offering these download and streaming services to businesses directly rather than the indexing part would remain fair use.
Yeah, exactly. I think that's the bigger issue. I think the indexing part is perfectly fine. There's really no way you can't consider that a fair use. We're in the age of Google where indexing content is, that's a business model these days. But how you distribute that content after you've indexed and how you provide access to it remains a thorny question at times. There's a reason why Google provides links to content and like a short snippet and nothing else.
So if the indexing is okay, but they end up ruling that offering that indexed content to clients is not okay, then what's the point of really finding that the indexed content is okay if these companies can't end up actually accessing that content anywhere?
Yeah. Well, I mean, I guess the theory is you could provide the date and timestamps and they could go seek it themselves, but then they would have to have the recording, and that's not likely to happen.
Right.
So, yeah, it kneecaps the service pretty thoroughly, I think.
Right, because as far as I know, those services aren't offered by the
by the networks. No, I don't believe they are. So it's definitely fascinating. But I really don't think. I see why the indexing part was a clear fair use. I think I agree with that verdict based on what I've seen. But yeah, there are other issues here, and that seems we're seeing and so forth weighing. And I think that if they're able to get the clip download and archiving part to be ruled an infringement, which like I said, that depends to me at least upon variables I don't know, then I think we still don't have TV eyes, basically.
All right. Well, I guess
keep an eye on it.
Keep an eye on it. I think the social utility plays a huge part here. This isn't like an indexing service that's giving you access to music. This is news stories, etc. So I think that'll play a role in whatever the decision ends up being. I think the dividing line ends up coming down to how much of the content that they're taking from these organizations ends up being entertainment content as opposed to real social utility content.
Yeah.
And then that would be I don't know, a thought of mine. So the Richard Prince story.
Yeah, this has been all over social media and all over the interwebs. There's no way you've ducked this. I'm sure you heard about this from somewhere at least.
I did. I have.
Yeah, basically, Richard Prince is a artist. I struggle with the word, but basically, he's found copyright controversy before. He actually had a very well-noted lawsuit against a photographer where Prince took the photographer's images and doodled on them and made minor changes to them, and the court largely ruled what he did was a fair use. Well, now he has a new exhibit, and in this exhibit, he has taken photos from Instagram and basically is selling them as they are with the user's name, and all he's done is add comments to the bottom that are designed to look like Instagram comments, and every single time he gives himself the last comment, which I find to be kind of jerky. But the long and short of it is he takes these photos, he has them in these giant wall-sized prints, and he's been selling them for apparently $90,000 to $100,000 a piece.
John, I need a new career, okay?
You need both, brother. You need both.
This story is unbelievable. How there are no expletives, there are no words to portray how shocked I am that someone would pay $90,000 for literally a screen grab of an Instagram photo with one more comment in the same text and font, it's just unbelievable.
Yeah. There's Richard Prince identifies himself as an appropriation artist, to which I say, wait a minute, I can actually name appropriation artists. This is not appropriation art. This is not, you got to go back to like the 60s and so forth and find appropriation art.
Yeah,
you know what I mean?
Richard Prince has a history of doing this. He's been sued in the past with mixed results. And, he claims that, and this ends up being the word of the day for us, I think, today, is that he claims that his work is transformative, which is the key question in fair use. And, how is adding one line transformative? That's not transformative. I mean, is copying something from an Instagram page and then putting it as a portrait transformative? I don't think so. I don't think that's enough. I don't think you've done enough to that work.
No.
You've basically changed the picture frame. That's all you've done. The actual photo is the exact same, and it's just put into a different medium. So,
and that's just it. I'm looking at these prints, and like I said, these are huge prints. And it looks like the photo takes up at least half of the frame total. You know what I mean? And if you discount just white space, I would say about 95% of it is directly from the Instagram page. You know what I mean? You actually look at the content and not the white border around it. It's pretty much the entire thing. And then you have all Prince did was add a sometimes snarky little comment at the end, and that's where it leaves. And it's crazy to me because what universe would this be considered fair use? It doesn't make sense.
I don't know. Let me just take a second here to really clarify what it is, what transformativeness really means, because we've used it quite a few times here. So basically, in U.S. copyright law, fair use is your affirmative defense to copyright infringement. You get to say, yes, I copied or I distributed or
I broke one of the exclusive rights, but
here's why it's okay. So one of the main things, especially when you're creating what's called a derivative work, which is basically a copyrighted work based on another copyrighted work, which is in this case the portrait based on the Instagram image, transformativeness becomes one of the justifications. You're going to say that your derivative work is so transformative that it really ends up hitting a completely different market and tone and use of that original work, so much so that the author really shouldn't have the exclusive right because what I did is so different. And so I don't know if you find that would be an adequate explanation.
Yeah. And the quick way I tell people to think about it is this: is the work you're creating going to compete directly with the original work, or is it doing something so new that it in no way, crosses over with? You know what I mean? The idea that you're going a different direction with it and bringing something truly new and original into the world.
So some good examples would be if you're using a work to comment or criticize a work. So you use a work in a way to,
a review,
cast a light on that original work. That's one of those transformative uses. A parody is transformative. A good parody is transformative. Even though, of course, you're using the material, it's for a specific purpose. And those are the type of purposes are generally found to be transformative. The perfect 10 in Google case is a type of transformativeness. If you're repurposing a work to aid someone else in identifying the first work, so you're using a little small image so that someone can find the main big image. In the case of a thumbnail on a search engine, that is generally found to be transformative as well. So I think those three examples give probably the listeners a good idea of what transformativeness is.
Yeah, but basically, this doesn't strike me as transformative. It just strikes me as an Instagram image.
Yeah.
I mean,
and the worst part is that even if it is transformative, that's only one part of a 4-part fair use test.
Yeah.
You could be transformative, but if you're selling it for $90,000 and not using it for, some sort of other reason, and you're using the whole thing, I think all the factors together here, if this individual would sue, which I think in the article you sent me, he is pretty certain he's not going to sue whoever, uploaded this photograph to Instagram. I think if they would win.
And it's not just this person. They've contacted others who had their work used in this exhibit, and they have said they're not going to sue either. In fact, one of the photos was actually taken from the Suicide Girl site. And instead of suing, what they did is they released their prints of Richard Prince's work for $90 a pop. So basically offering Richard Prince's prints for a 99% discount. Is that somewhere in that range?
I think you actually need one more decimal point there.
199.9% discount. That's probably accurate. And okay, and very interesting. We're on DIY photography for this particular article. These are the ones who broke the story. There's a interesting little poll at the bottom that said, if your photo was used, how would you respond? What would you do? Would you sue? I mean, and then like others, definitely not. It's a fair use, and I have no claim over the photo. I think it's wrong, but it's not worth a court case. Or I'd slap him with a lawsuit before he could finish counting the money. The people that say they would sue him have 86% of the vote. As I'm saying this,
John, can I confide in you with a huge secret?
Sure.
I voted.
So did I.
What'd you go with?
I'd say I'd slap him with a lawsuit.
Oh, me too. So listeners, we have to be very honest about this. Those numbers could be skewed by our 2 votes.
Yeah, our 2 votes. But the other 3,682 people who voted for that one answer, I cannot speak for. Yeah, it's a fascinating story. But I'm surprised that there isn't more talk. But then again, it's very possible the people who are thinking about suing him are following the advice of a strong legal counsel and not talking about it right now. And there may be other action going on. Maybe,
but I think we've talked about this a few times, is that the bar for a federal copyright lawsuit is so high that $90,000, that seems like a lot of money to you and I, and seems like a lot of money to most people, just doesn't, it doesn't wheel the, it doesn't grease the wheels.
And it's especially true. It's especially true if you don't have a copyright registration and you can't get those yummy statutory damages.
That's right. I mean, in this case where you have clear proof of how much he made off of it, it's a lot easier because you have your number. He's declared himself he sold it for $90,000. So at least that way you can investigate with a lawyer how much it's going to cost you to litigate, which in most cases can be hundreds of thousands of dollars. But in some cases, you can find some copyright lawyers who will take it on a contingency, where they'll basically agree to take a percentage of what you win. But Richard Prince has a history of defending his lawsuits very vigilantly, and so it may just not be financially feasible to launch the suit, which is another good reason why copyright small claims court is.
And it's worth noting that if you have a timely copyright registration, you can also win attorney's fees. But I suspect, since these are Instagram users, we're talking about a lot of people who do not have timely copyright registrations.
No.
I mean, that's just a strong bet there.
Not only do they not have registrations, but most people can't float the money it takes to win it back. You know what I mean? You have all these expenses in the meantime, and the promise of even a strong chance of winning your legal fees back isn't enough because you just can't get there. Can't get to the end.
And what you need, realistically, is a photographer who has the means to file the lawsuit, the means to fight it, and the both interest and determination to see it through, which is, it turns out, what Pinterest has stumbled across.
Yes, they have. And before we transition to the next story, however, I'm thinking about starting an Instagram account, because maybe I would be the perfect person to sue this gentleman. I could do it pro se.
Yes, you could. I mean, usually you say that pro se is, anyone who represents himself as a fool for a client. But in your case, I would beg to differ.
So, are you ready for my first official legal advice of the podcast history?
Okay, go
so,
for it.
If you receive a DMCA takedown request, don't ignore it.
Oh, okay.
Yeah.
All right. Yeah. All right. Well, then that's solid legal advice from Evan Sherez, attorney at law.
Yes.
Yeah, this is definitely solid legal advice. That's probably the safest legal advice you could ever give in a blanket statement. Definitely true. Do not ignore DMC notice because it's exactly what Pinterest is being accused of doing. Basically, a photographer. I'm trying to find the guy's name. I just had it and I just scrolled away from it and lost it. It's Christopher Buffoli, I think is how you say that. It's good enough.
Yeah,
it's gonna be good enough. He's been a very, very active plaintiff in copyright infringement lawsuits, by the way. This isn't his first rodeo. But he is suing Pinterest, saying that he has filed DMCA notices with the site and that Pinterest has either not removed all the content, has not acted enough to protect his work, and generally speaking, has contributed to the infringement of his work on the site.
Right. Whenever I start to read a lawsuit story or, something you send me, John, I'm always looking at, okay, what's their way to get around DMCA safe harbor? Because everyone has to find a way to remove this, safe harbor from these content hosts. And
that's the shield.
Yeah, that's the shield that the DMCA gives third-party content providers in exchange for their obligation to take down copyrighted material when someone sends a request their way, and to have a meaningful repeat infringer policy, which basically means that if someone is constantly, uploading other people's copyrighted material, they get their butt kicked off the site. And so I'm usually looking for a lack of a meaningful repeat infringer policy. Maybe they have some kind of policy, but it's not that good because a lot of cases are really in that area now. Because if you're, not looking at IP addresses and you're not looking at that kind of thing, you're kind of behind the times, and you might have grounds to have your safe harbor removed.
And that was one of the things that nailed Groove Shark. It was one of many, but it was one of the key things that nailed Groove Shark.
Right, and so I finally was looking for it, and I'm like, oh, well, they just didn't remove it after he sent the request, which is the silliest way, to lose a lot of money. The facts here are that in August 2014, he issued a number of takedowns, and to date, according to him at least, 56 of his photos are still where he found them almost a year ago. And so there's really no excuse for that. And so, I smell a settlement coming, and it's going to come quick.
Yeah. If what he says is accurate and his DMCA notices are true and complete, and given, like I said, this is not this guy's first rodeo, I strongly suspect that you were right.
Yeah.
Because he's also sued Google and Imager, as in Twitter and others as well. And he's actually won settlements in most of those cases. He is very aggressive and keeps very, very good records when his photos go down. He truly is very, very talented at this, and he has got a pretty good track record overall with at least securing positive settlements. So, yeah, I think he's got a good argument here, and it's going to be one to watch because a lot of photographers. There's been a lot of quiet seething at Pinterest among photographers, and many saying that one of the issues is that they're not cooperative enough at removing photos. Well, now someone's taking them to task for it, and I know who the photographers are rooting for. And you can tell in the comments here on Petapixel. Okay. Now, shifting gears, if you think that the soundtrack to the latest movie you're watching sounds a little familiar, you're not alone. Apparently, the American Federation for Musicians, or AFM, agrees with you. And they are suing Columbia Pictures, Paramount Pictures, 20th Century Fox, Universal Studios, Disney, and Warner Brothers. I don't think anyone big's missing for copyright for a variety of things. But the biggest here is a breach of contract, saying that they are unlawfully reusing soundtrack recordings, and that their contract, which apparently this has been a part of their agreements since the 60s, requires them to only use the music in the movie it was produced for.
Which makes a lot of sense, right? If you're a union representing all of these composers, one of the first things you're going to argue for is that, hey, that work that we made for you, we want you to come back and ask us to do it again for a different movie with a different feeling because we want to keep eating and having houses. So you can only use it for this one.
Or at the very least, come back and get a new license to use it in a different movie.
Yeah, yeah. Well, I mean, I think that's just a
You know what I mean? I know what you mean.
So yeah, apparently that was the deal, and then I certainly always feel like I'm hearing the same soundtracks over and over again. That's probably just because I don't have a very sophisticated ear when it comes to classical music. But among some of the offending titles was that a minute and 10 seconds of music from Titanic was used in This Means War, the Reese Witherspoon and Chris Pine, and who's the third guy in that movie? He played Bane.
Oh, yeah. And I can... Dude.
Anyways, that guy. They were in that movie. What else? Apparently some music from Battle for the Planet of the Apes was used in Argo, and so on and so on. And so they're seeking damages for the breach of the contract. Tom Hardy. Yes.
I'll get there eventually.
Sorry, Tom.
Sorry, Tom. We love you. I'm sure we do. Yeah. But yeah, it's interesting. And one thing I did notice, it's kind of bizarre. Like, okay, Titanic and This Means War. Okay, they're both those sappy romantic-ish movies. You know, you can kind of see that one. But Planet of the Apes and Argo?
Well, they're both dramatic films.
Yeah,
so I can see maybe the build-up type of ambiance being the type of music that you're searching for. If I had to guess, I would probably guess that these is like stubborn musical directors, or even higher up than that, directors who are like, I know what I want for this number, and it has to be this. And then legal saying, well, we can't really do that. And then a stubborn director being like, we're using this.
Yeah.
And eventually you get caught.
And it sounds like it's not just that they got caught. It's that this has been snowballing for some time, to the point that the AFM's like, okay, we've got to step in and do something illegal. Like once or twice, accidents happen, but the numbers keep ticking up, So it seems like it's almost this type of deal where they just lost patience over it.
You're right. I that would probably make more sense than, discovering it. It probably happens, and you want a good relationship with the people who are basically paying all of your members.
Yeah.
It's things have to be pretty bad when you sue your employer, basically.
Yeah. No one wants to sue their employer if they don't absolutely positively have to.
That's right.
But so yeah, it's very interesting, and it's going to be, even though it's really more of a contract law case than a copyright one, it definitely is copyright adjacent because of the nature of the works involved and because how they're being used. So,
well, it seems pretty cut and dry to me. I think if the allegations here are true, and there's a plain provision in the contract that says that, you can't reuse this without our permission, and then you reuse it without their permission, well, you're going to end up paying.
Yeah, very true. Well, Sherlock Holmes. When I saw this headline, I thought like everyone else, oh, really? Again? We're going down this path? Again? Ugh. Okay, now just to sort of backtrack a little bit here, Sir Arthur Conan Doyle wrote the Sherlock Holmes books, which I highly recommend. They are wonderful stories, and I always associate them with car rides as a kid because we didn't have cell phones when I was a kid, so I read Sherlock Holmes stories while we drove to Grandma and Grandpa's house. That's what I did.
But that's great.
No, I'm a huge Sherlock Holmes buff because of it. And the estate of Sir Arthur Conan Doyle sued an editor of basically what you could think of as fan fiction. They were fan-created stories of Sherlock Holmes claiming copyright infringement. Well, this particular editor fought back, and it was ruled in this lawsuit that nearly all of the Sherlock Holmes stories, all but 10, the last 10 specifically, were in the public domain. And that was the big final outcome of that whole case. It seems to be pretty much done now. But I think it is done. But the result of it, so basically everything of Sherlock Holmes except those last 10 stories are so old that copyright has expired, and you can do with them what you please. You can write new stories based upon them. You can publish them. You can print them. You can print them on big stacks of paper and toss it off a building if you so desire. It's your have fun. But those last 10 do remain in copyright. They were published between 1923 and 1927.
So
now, yeah, brings us to the new stories.
This is a pretty confusing point of law, and it even took me a minute to really understand what it means when part or the original and later derivative works, so like 20 of the 30 that he wrote of, those numbers aren't exactly accurate, but it's something around those numbers. When they go into the public domain, but some of the stories are not in the public domain, like how do those two interact with each other? And I think you summed it up pretty well in that the characters become usable,
yeah,
and the character traits that are fleshed out in those stories that do go into the public domain are usable. But any plot lines that are not in the public domain, that are sufficiently creative to really be their own derivative work, remain unusable. So, if one of the stories was Sherlock Holmes goes to space.
I want to read this now.
Sherlock Holmes goes to space. The question becomes then, can you now write a story about Sherlock Holmes going to space if it's a very different story from the first one? What if Sherlock Holmes went to Mars and then, in this one he's going to the moon? It becomes a copyright substantial similarity question between those two plot lines. And so, that's what the case is here, is that the estate, who is really trying to squeeze every last cent out of, Sir Arthur Conan's work, is trying to say that this new piece that's come out is too close to one of the stories that remains copywritten, which are generally the story of Sherlock Holmes in retirement.
Yeah, and we've seen this division up of a character before. I don't know if you remember the Superman copyright termination fight, where there was a whole issue about what rights the original creators could terminate, and they were basically dividing up his superpowers among copyright holders. It was actually kind of funny. But yeah, these later stories deal pretty much with his retirement, and there's a new movie coming out. It stars another Sir, Ian McKellen.
Love him.
Love Sir Ian McKellen. Yeah. And his bromance with Patrick Stewart is truly inspirational to all peoples. But yeah, he apparently is playing... He is playing Sherlock Holmes, an aged Sherlock Holmes, and it's based upon a 2005 novel called A Slight Trick of the Mind. And basically, according to the estate of Sir Arthur Conan Doyle, elements of this story pull heavily from the various stories that are still under copyright, including one of the stories, apparently they describe how Holmes arranged his office to make potential clients uncomfortable so he could test and probe them better, which I just thought that was a therapist thing. I didn't think it was actually a detective thing too. But also,
this is what I was alluding to earlier, in that, maybe or maybe not, the concept of Sherlock Holmes being retired is owned, remains to be owned by the estate. And that comes down to a question of how similar the story you write is to not just to some of the stories that exist out there. So if you write one that he's retired but doing something completely different, I mean, would that end up being copyright violation? I don't think so. Just like, in this case, they end up being just too similar. And I think that the two quotes that the the rap.com provides for us kind of make it evident that, they really borrowed the plot line way too closely.
Yeah, borrowed the plot line and borrowed some pretty specific details too, not just general plot points, but a lot of individual, very specific elements, and that could spell trouble for both this author and Miramax, the producers of the film.
So here are the two lines that the rap provides for us, and here's a passage from the book. Quote: "It is my habit to sit with my back to the window and to place my visitors in the opposite chair where the light falls full upon them." Mr. James Dodd seemed somewhat at loss how to begin the interview. I did not attempt to help him, for his silence gave me more time for observation. I found it wise to impress clients with a sense of power, and so I gave him some of my conclusions. By the way, my speaking is a little off because I can hear myself in the background. I don't know why that's happening, but
I'll read the second one for you.
Go ahead.
This is from Cullen's work, the book. The first one you wrote was from Sir Arthur Conan Doyle's work. As was my usual custom, I sat with my back to the window and invited my visitor into the opposite armchair, where from his vantage point I became obscured by the brightness of the outside light, and he, from mine, was illuminated with perfect clarity. Initially, Mr. Keller appeared uncomfortable in my presence, and he seemed at a loss for words. I made no effort to ease his discomfort, but used his awkward silence instead as an opportunity to observe him more closely. I believe that it's always my advantage to give clients a sense of their own vulnerability, and so, having reached my conclusions regarding his visit, I was quick to instill such a feeling in him.
So yeah, it reminds me of the effort that like high school kids will do to like use synonyms.
Yeah.
To try to fool a teacher into thinking they didn't
plagiarize. Quick, pad the sentences out. We're not reaching the word count.
Yeah. You copy paste something and then just like use the synonym finder to change it. That's what it reminds me of. It's pretty much identical, and so this isn't two different retirement stories. This is clearly.
I agree with it, and I think now, and so this is one of the weird things is even though everyone believed, and I suppose correctly believed, that the previous ruling was a major blow to the Conan Doyle estate, I think by maybe validating those 10 works as being within copyright, it may seriously help them in this case, at least.
Well, I think most people have the reaction that we had when we looked at their case, or this case, was because their last argument was just so outrageous.
Yeah. The whole idea of evolving character and...
Right, which is that they didn't want the time to start ticking for how long their copyright lasts until they claimed the last story was written. They were saying that the character of Sherlock Holmes was only truly developed because he's so complex when the last story was written, which is really ridiculous because once a character is copyrightable, that threshold is met, it's met. You can't say the more complicated he is, the longer my copyright becomes, because only until I decided that the character is closed will the 80 or 90 some years begin to toll. And that argument was novel but rejected, and so that's why I was skeptical, reading that they were suing again. But they were left with a very small scope of copyright, which is these 9 or 10 stories, and the story seems to be directly borrowed from that. So
yeah, it seems like this one hit just the right notes to possibly give them a real case to stand on here.
Mm-hmm.
Well, we also have to take a quick update here on the Happy Birthday lawsuit. Speaking of things
thanks, John. I just turned 28 on the 25th. I didn't think you'd remember.
Oh, so actually, I didn't know you turned 28. That's a happy birthday.
Thank you.
I would sing happy birthday for you on the podcast, but I don't want to get sued. Because, as we're still finding out, there's a great debate as to whether or not happy birthday is in the public domain. Sure, it might seem crazy that something from the late 1800s is still under copyright in 2015, but there may actually be a case where it is.
Well, when you say the word late 1800s, you're really taking one side of it, right? Because someone else is alleging that Well, it may have been around. Someone wrote it, but never really published it, and it was really only published in 1935 when the people who I eventually bought the copyright from filed for the copyright, and so that's why it remains under copyright. Even though, like you said, there's some claim that people were singing it, in the late 1800s and early 1900s.
Yeah, and that's one of the things that seems kind of bizarre to a lot of people about this, and what this case really hinges upon. It's pretty widely known that the origins of the song Happy Birthday to You go into the late 1900s.
1800s.
1800. Yeah, 1800s. Late 19th century 1800s. See, I meant to say one or the other, ended up saying both. But yeah, the late 1800s. It's pretty well known. Now, but the issue is, as you said, there's not significant evidence of it being published. The lyrics first appeared in a songbook in 1924, and the piano arrangement for it first appeared in 1935, which is what Warner Chappell Music today bases its copyright claims on it and uses it for millions of dollars per year in licensing fees.
Right.
And it's also why you get obnoxious songs in restaurants.
And they come over to you, and
the little cheap cake, or the
Yeah.
ice cream with the candle in it. Yeah.
5 employees who are very clearly not enthusiastic about it being your birthday, but putting on brave faces.
Yeah.
So this is why the system has changed, because the whole concept of copyright both expiring if you publish without filing a registration, which was the case at the time, and copyright term only starting to toll at it when you publish, or when it was just a giant mess. And so that's why they changed to copyright being automatic, lasts a certain amount of time, and go.
Yeah. And it's super frustrating in this case, because one of the issues that's been going on for a long time is there's been this question of whether or not Happy Birthday to You is copyrighted, but no one has sued over, no one's taken this matter to court, because Warner Chappell's licensing fees are pretty much always cheaper than a lawsuit. It's much, much easier to pay them for the fee and then go away.
Right. And now we have a class action lawsuit, or
Exactly.
what is it trying to be a class action lawsuit? They're trying to get certification as a class, suing even the owner, saying that you don't own a copyright in Happy Birthday, and we're all going to band together to get our money back.
Yeah, exactly. Now, as you noted, Warner Chappell's arguing that the clock didn't start ticking until it was published.
That's right.
But it seems very odd to a lot of people that copyright would not affix at the time that it was first created, basically. But there's no evidence, at least that we've been able to find, that it was fixed into that tangible medium of expression, published or otherwise met the criteria for copyright underneath what would have been at that time the Copyright Act in 1909, I guess. It probably would have happened after 1909, I'm guessing. So yeah, it's a very, very bizarre issue, and now the judge is trying to look at whether the copyright was abandoned in the work. Specifically, whether the original creators of it had at some point actively abandoned the copyright, or expressed some kind of an intent to not enforce it, basically. And that, under the laws that existed at that time, could also cost them the copyright of it.
Yeah, this seems like a nightmare case from an evidence point of view. You're talking about things that happened almost 100 years ago, and you're trying to look into the intent of the original creators as to whether they meant to abandon or whether they had published, et cetera, et cetera. And so, I certainly don't envy the plaintiff's position here.
Yeah, and what percentage of books from the late 1800s survived into 2015 in any format, digital, physical, or otherwise? It can't be very high.
Very few.
I'm sure it's a low number. So there's at least a decent chance that somewhere this song was published and we just lost it. It's gone. It's lost to the world. The final surviving one was 1924 and 1935, respectively, both of which would remain in copyright for quite some time. And in fact, I just checked, in the United States, barring this lawsuit overturning the copyrightability of the song, you can expect Happy Birthday to remain in copyright until 2030.
Wow.
2030 is apparently the date we can expect it to become fully public domain. 95 years after the registration, yeah, that would be it, wouldn't it?
You know, I'll put it down on my calendar.
Yeah. Put a reminder in your iPhone. Hang on a second. Siri, remind me January 1st, 2030. Happy birthday is public domain. There you go. Done.
You know, if you continue to use Apple products and continue to
have an iCloud account and all that, I'll actually get the reminder.
You are actually going to get that reminder in 15 years, a little under 15 years.
Yeah, it'll be 9.
You have to
9 it set it for me. It set it for me to 9 a.m. on January 1st, 2030. I have a reminder set now so we'll see what happens. See if I get to use that or not.
All right. Well, I think it brings us to our last story and the Trans-Pacific Partnership.
Yeah, it's the Senate basically this week took what is considered a step toward Trans-Pacific Partnership, but also other trade legislation approval, and that it is approved fast-track legislation, which basically would mean any trade negotiations that come before the Senate would get an up and down vote, and that would be it. There would be no real negotiation, no conversation, no discussion. You get to look at it, you get to vote on it, and that's it. You know,
the Senate is an interesting body, right? You have to vote in advance to see if you can vote later in a regular up and down fashion. It's a very strange body, and the whole filibuster. Oh, you need 60 votes to proceed to a 50 vote. It just seems very inefficient to me.
Yeah.
But yeah, the Trans-Pacific Partnership is definitely topic du jour online and with the mainstream media. I hear a lot of different things about it, a lot of uninformed things about it. One of the biggest points I think I see online is that, why don't we get to read it? It's being negotiated in secret, and it's this corporate takeover bill. It's like, if you've ever been part of any sort of negotiation, you know that a deal usually has, 100 different forms before the final one. And so this whole point that, it's being negotiated in secret and we can't see the copy, if every copy of this agreement was open to the public, before it was changed or modified or, slashed and this and that, it would just never get done. And so I personally don't think there is really any gripe in that, at least that argument, which is that we don't know exactly what's in it yet. What are your thoughts?
I agree, and it's strange because this idea of publicly discussing trade agreements is a very recent phenomenon, brought on not just by the internet, but like social media era internet.
Right.
It used to be that trade negotiations were in secret and no one cared, no one noticed. And part of it, I think, may be that there's some concern that maybe trade negotiations are backdoors for legislation that couldn't get passed normally. But that's one of the things about it, is that it still has to be approved by Congress.
Right, which, I do understand some people's perspective is not exactly the highest bar, for scrutiny. And
but take that one up with Congress, not the actual.
Exactly. Well, here's the thing. I listened to Obama's address on this. He addressed it in his weekly, and it was on MSNBC does a weekly address, and he said, "Listen, I appreciate your concerns about how this, might be a vessel for certain, corporate handouts, etc. Let me reassure you what this is really meant to do. This is an agreement that is intended to bolster our economic ties, with the region, in a time where it's almost a zero-sum game with some of our competitors. And this deal will make sure that, it's U.S. businesses and, other North American businesses that get to deal with, Thailand, Vietnam, and Japan, etc., and not China. And so I don't see what's wrong with that. I feel like that's a good thing.
And there are some copyright provisions in it, from my understanding, in the last leaks and so forth, indicated that mostly those provisions were the United States taking and trying to help encourage other nations adopt U.S.-like law, including things like anti-circumvention rules. And yes, some of these things are controversial in the U.S., but it doesn't seem to involve much drastic change in U.S. copyright law, if any. It seems more about taking U.S. standards and putting them overseas. Now, that's controversial enough by itself, and there is a concern that the TPP will make it harder to reform and change U.S. copyright law. But as far as it being a drastic, corporate change and an overhaul of U.S. copyright law, it's definitely not that.
Right, and a lot of these countries have rampant piracy problems akin to like what we had 15 years ago, when everything and everyone was able to get anything and everyone and everything. And so, although I have some doubts as to whether there's real enforceability in a lot of these countries, even if you can get laws on the books, I don't have a problem with some of the U.S. standards being applied to some of these other countries where you could go into any mall and find 1,000 pirated DVDs of whatever you're looking for. So I've been there myself. So I guess that's what colors my opinion.
It's interesting. Though I have not been to any of the countries in the TPP, but I have seen it in Hungary, in Budapest, which you might expect. So you're sort of getting into the Eastern European bloc with that. But yeah, it is interesting, and I think that to me, I think there's a lot of alarmist conversation here, and it's somewhat reminiscent of Sopa and Pippa to me. And that whether you like Sopa or Pippa or not, I was kind of neutral on them myself. I didn't think they were going to have much use either way, personally. But the alarmist nature of it and the things people were saying that the law would do were completely out of whack with what it actually said. And that annoyed me far more than the legislation dying. But like I said, I was kind of meh on Sopa and Pippa myself. I just didn't care. But yeah, the vitriol and the way the debate was handled, I found, was deeply concerning.
I agree with you, and I think it's unfortunately just kind of par for the course when it comes to politics. If you can't argue against what's in the bill, just make something up and say it's in the bill. And
you gotta have something that's soundbite ready. And then once you've got that, you can throw it out there and go. And it seems to be exactly what is happening in a lot of these debates in copyright, including TPP and Sopa and Pippa. And I'm not going to lie, all sides of this discussion do it. It's not just the copyright reformists that do it, but yeah, it's just the nature of the debate, it seems.
So, John, one last very important point. Did you see Game of Thrones?
No, I did not. I have not actually ever seen an episode of Game of Thrones.
Oh, did we ever talk about this before? Oh, it was incredible. Never mind then. Well, it was a pleasure talking to you again. And
I think it's spoiler free. I do actually plan on watching it at some point. Now, especially now that I actually have cable in the house, it might be a bigger priority. I did not actually have. There's no way I could have caught any season of Game of Thrones prior to the most recent one. Okay. I am a reverse cord cutter in a weird way.
Well, it's curious because we have talked about how there are many standalone services coming, and you were quite enthusiastic about that.
Yes, I am, and I still am, but I don't know. But one of my main problems with all those standalone services is I don't know if I want a standalone service for every single channel, like CBS is getting one, HBO is getting one. It seems a little bit crazy to get all these individual standalone services. But then again, that's also kind of the idea is that if I want HBO but don't want to pay for home and garden television, I should be able to get HBO.
All right, that's fair enough.
All right. Well, on that note, everyone, my name is Jonathan Bailey. I am from the site Plagiarism Today, which can be found at plagiarismtoday.com. And I am username Plagiarism Today at pretty much all the places, Twitter, Facebook, etc., etc. Even Pinterest, who is being sued. I think I have a Pinterest account.
And my name is Evan Sherris. You can find me on Twitter at Evan Sherris. And I am a copyright and trademark attorney living in Washington, D.C. Feel free to reach out to me on Twitter if you want to talk or have any legal questions. And yeah, we'll see you guys next time.
And his name is Evan Sherez for audio listeners. Sheres, not Sherez. Don't get it right, people. Get it right. Well, thank you very much, Evan. Great chatting with you, and I will speak to you next week.